Good morning, everyone. I hope you're all doing well today. Attendees, kindly note you are requested to mute your audios and turn off your videos unless requested otherwise. Thank you. The heart of our national economy long has been faith in the value of competition. Good morning, everyone, esteemed speaker, dignitaries, professors, and fellow students. On behalf of CMI University School of Legal Studies, in collaboration with the Competition Commission of India, I welcome you all to the session on an overview of competition law in India, addressed by Shri K.P. Anand, Joint Director of Law at the Competition Commission of India. To begin with, I request Pranav, a third-year student of BBA LLB, to render the invocation song.
Shri Karnanatham Satatam Bhajeham Shri Karnanatham Satatam Bhajeham Shri Adikeshava Sodare Salputram Matrahitam Paripalanavadam Shivakarahanya Punarpunyajanyam Shri Karnanatham Subramanya Avaraja Pramukha Mushika Vahana Sadmukha Varanam Ashtadravya Mahavana Priyam Ashtaraga Harasiddhi Vinayaka Shri Karnanatham Vyasoktika Mamayanaadi Likhitam Siddhi Buddhi Yoga Mangalalasitam Agastya Muni Kshana Darpadiharam Shubha Kaveri Sreshti Pradakaram Vigna Nivaraka Mukti Pradayaka Namami Heram Pada Pangeruha Shri Karna Gamappa Mamappa Magamabani Pa Mamappa Magamaga Nini Sasaka Mamappa Bani Sasaka Sasanini Papa Gamabani Sagamabani Shri Karnanatham Shri Karnanatham.
Thank you, Pranav. That was indeed a feast to the ears. The Competition Commission follows the philosophy of modern competition laws, prohibiting anti-competitive agreements, the abuse of dominant position by enterprises, and subsequently regulating combinations which may cause an appreciable adverse effect on competition within India. Having been established by the central government in 2003, the Competition Commission of India has been committed towards eliminating practices that have an adverse effect on competition, to promote and sustain competition and protect the interests of consumers and ensure freedom of trade in the markets of India. I now invite Professor Dr. Vijay Praneshwaran, Director, CMI University School of Legal Studies, to deliver the welcome address and introduce to us our guest speaker.
Thank you, Maria. On behalf of the Board of Governors, the Dean, faculty, and students, I extend a very warm welcome to all present here, especially to the guest speaker, Shri K.P. Anand, Joint Director, Law, Competition Commission of India. Shri K.P. Anand is an alumnus of the Tamil Nadu Dr. Ambedkar Law University School of Excellence, having done his BA/BL honors. He went on to pursue his Master of Law in Madras University. Thereafter, he has practiced law for about 6 years in various courts, including the High Court of Judicature at Madras. Thereafter, he joined the Competition Commission of India as the Deputy Director Law and was promoted as the Joint Director with effect from 1st January 2021. We are honored to have you, sir, on this day, and we are happy that you accepted our invitation to address our students. I would just like to share an anecdote with my students. I was conversing with Shri KP Anand over phone and over mail. Keeping by his voice and his email, I thought somebody who was like 55 plus, KP Anand. I had a shock of my life when I saw the photograph yesterday. That speaks about the person at a very young age. He's the Joint Director of Competition Commission of India, a statutory commission. And this should be like an inspiration to all our students. And I hope we do get some internship also from CCI, and our students are very eager to follow you. Thank you very much, sir, for accepting our invitation. Hearty welcome to this guest lecture on general overview of competition law in India. I also welcome all the teachers present here, the university officials, the students. Without further elaborating, welcome to everyone, and let's get into the guest lecture. Thank you.
Good morning, and once again, thank you, sir, since you have given this platform for us. Since Competition Commission, as a competition law, we have a mandate to do more advocacy events. And now, since Southern Regional Office, they have opened the Southern Regional Office, it is a great opportunity to work with other law colleges in Southern India. So we are so specific. So previously, they have the habit of having a connection only with the national law schools. So once the regional offices comes up in Chennai, so we thought it has to trickle down to other law colleges also. So that is our endeavor, sir. And not only that, since you have mentioned, before entering into the topic, I have to tell you, this internship programs, now we are planning to start from the regional offices also, sir. Two students from the colleges we are selecting for the regional offices. First, initially with two students we are starting. I think probably your students, they can apply for next month or next to next month. So from the next to next month, they are planning to start from the regional offices also. So this opportunities, those who cannot avail to travel and stay in Delhi for 1 month, they can utilize this opportunity. And they can come to Chennai and they can understand the competition law by attaching with us. But apart from that, in my opinion, students from South India, they have to go to Delhi office, because during the internship, they are making you to understand how the regulator is working. So that understanding, today I am going to cover that only, but you can see yourself from attaching with the regulator for 1 month, and they are paying internship also. So please use that opportunity. Those who are not able to go to Delhi, so they can avail the opportunity by taking these two internships in the regional offices also. So now we are starting that also. Since sir has mentioned that, before entering into the topic, I thought I have to tell to your student about this so that they can avail the opportunity, sir. So, sir, today our topic is general overview of competition law in India. So, why? What is the necessity of competition law in India? So, since there is a lot of issues happening in Karnataka related with this Nandini milk industry versus Amul. So, what is the competition in that? Even there is an issue of Amul. Amul is one of the dominant player, and he's that Amul is trying to enter the Karnataka. But when the Amul is entering the Karnataka, what is the impact of Nandini, the milk product of Karnataka? And there is an we have here in Tamil Nadu also we have our own brand. In Pondicherry they have their own brand. The state governments, they are having their own brands. So after this lecture, you need to understand, so what is the significance of competition law at present, and how these issues are related with that. This is one issue, hot topic happening in Karnataka. Next thing, important thing, since your college is in Bangalore, one of the IT capital of India. So the Competition Commission imposed the penalty of some 1,700 crores against this Google. So what is the issue of Google? Why? What is the abuse of dominance? Why the Google is so important in our IT revolution? Whatever IT revolution happening in India, especially Bangalore, Chennai, and Hyderabad, the IT capitals. So the Google and other companies, IT companies, they are playing a big role. And what is the role of competition? How the competition commission has to play at this market structure? How? So this kind of things, as a student of competition law, see, this competition law is an economics law, the law of it, more to the economics than to the law. But however, whatever economics plays, finally, the lawyers are going to play a major role in the competition law. Therefore, now as far we need to understand what is the role played by the competition commission, what is the role in future for the competition commission, and how the competition law is going to change the market dynamics of the whole India or the whole world. If you take the world as a one village, then whole world, how it is going to have an impact. So we will move to our topic, general overview of competition law. So in this, next step in the okay, yeah. So this is the timeline. If you see, the competition law, the predecessor of competition law is this Monopoly Restrictive Trade Practices Act, 1969. This act, this is basically related with the prohibition of monopolistic and unfair and restrictive trade practices. And we know very well, before 1991, the liberalization happened, LPG era. Before that, a government is in the prohibition stage of monopolistic. So they are protecting the market. That is, the market is a closed economy. Economy is also closed. Government controlled economy, and the market is totally closed. So during that time, we don't need such a competition. There is no level playing field. The government decides everything. It is a license Raj regime. So the government always decides the thing. So that time we have this Monopoly Restrictive Trade Practices Act, and it is not covering much of the act. Only it is covering, it is strengthening the hands of the license Raj regime. Then we got liberalization era happened, LPG in 1991. Then after this, the difficulty arose to the administrators how to handle the new market, the emerging market. Then they set up a committee, the parliamentary committee. Yashwant Singha was part of that parliamentary committee, previous finance minister. So he was the, we can say that the first proponent of this Competition Act in India. And thereby they had a discussion in the parliament, and then the act came into the existence of Competition Act 2002 to meet the requirement of highly competitive market, and we need to create a level playing field. This previous acts, they are supporting only the public sector undertaking or the Indian companies. Now we want to create a level playing field for all the investors or all the foreign the multinational companies who entered the Indian market. So in order to create a level playing field, this new act was enacted, that is called the Competition Act. So we'll go into see the objectives of the act. So what are the objectives? If you see the objectives, it is to eliminate the practices having adverse effect on competition. This is the first objective. And this particular objective is mentioned in our act itself, Competition Act itself. And to promote and sustain competition and to protect the interest of consumers. So though it is not a Consumer Protection Act, but one of the objectives is to protect the interest of consumers and to ensure the freedom of trade carried on by other participants in markets in India. So all these four conditions, markets in India. So that we have to take care of all these things, how this particular thing is happening in Indian markets. So it is just like the Competition Act have a bird's eye view on all the market regulators, not a market regulators as all the market or all the sectors. Like SEBI is having it on securities market, and Insurance Regulatory Authority of India, they are having it in the insurance market. The role of Competition Commission is to look into all the markets, the bird's eye view from all the markets, and we have to protect all these things. We have to promote and sustain competition, eliminate the practices, whatever practices which is having the adverse effect on competition, and they ensure the freedom of trade and carried on by other participants in the market. So, structure of the commission, if you look into the commission, that this is the commission. Now the commission sits in Delhi. We have 3 members, 2 members and 1 chairperson. But previously the commission, as per the act, it was 7, was 6 members and 1 chairperson. Due to some difficulties, the government has reduced, downsized the commission's number of members in the commission. Now it is 2 and 1 chairperson. Due to some procedural issue, now we have 1 acting chairwoman and 1 member only. So with this, we are running the commission. Commission is sitting in Delhi and they can sit in anywhere in India. It is provided in the act. If the commissioner deems appropriate, so they can constitute anywhere in India. So apart from this, the commission consists of a secretary who is the nodal officer for all the communications, and she is the head of the, as far as the CCA is concerned, secretary is the administrative head. And she is reporting to the chairperson, chairman or the chairwoman. She is the administrative head, and the secretary is the second in command. And with her, all the secretariat, HR, finance, and service divisions, they'll report to secretary, and the regional officers like Chennai, Mumbai, and Kolkata. We have now 3 regional offices. Chennai first office opened in Chennai, then Mumbai, then Kolkata. 3 regional officers, and we have an investigating arm called Director General Office, the Office of Director General. That is the investigating wing of the commission. And we have advisors. These are the different divisions of the commission: advocacy, economics. Since it is an economic law, this competition law is an economic law. Economics plays a vital role, even for research, for the data collection, and for proving the case and evidence. So I will explain you how the economics is so important to understand the competition law, or the competition violation, rather, I have to say. So then advocacy, antitrust is that section 3 and 4 violations comes under antitrust, and combination section 5 and 6. So you can call this 4 as a 4 important pillars of competition law. These 4 sections, section 3, 4, and section 5 and 6. Then we have a legal division, capacity building division, international cooperation. We have cooperation with other jurisdictions also, or other country competition authorities. We have a MOU with them. So our international cooperation will take care of that. We are part of OECD competition authorities, and we are the part of international competition organizations. There is a is there. So we are part of so many international collaborations also, so that we can learn from them also, and we are also providing, contributing more to the international development of jurisprudence. It's not going. Okay, so who can approach the commission? So now, before entering into the nitty-gritties of this particular slide I prepared it before this amendment came. So yesterday they notified the amendment. We got the new competition amendment 2013. So in that amendment, they have incorporated 2023, and they have incorporated so many important. They have amended so many important provisions. So certain things are not covered here, but I will try to accommodate that in the last slides. I just mentioned those things in the last slides. So now see, this is the procedure. Once the case, how the case are developed, who can approach the competition commission? Any person or consumer or their association or trade association. So they can file. We don't call it as a complaint. See, competition law in India is a civil law. It is not a criminal law. Therefore, here we call it as we call the that whatever complaint they are filing, whatever grievance they have, that association or person, we call it as information. Rather, we will not call it as a complaint. So it is since it is a civil law, we call it as an information, and we receive references from central government, state government, and statutory authority also. This is also possible. Even we got cases from Pune Municipal Authority. Pune Municipal Authority filed some 3 or 4 LP leniency petition cases against cartel cases against the tenders. And sumoto, we have a power to take sumoto cases also. The commission usually used to find out. So what is happening in the market, and the prices of steel are increasing, cement are increasing. So those markets, the commission can take up a sumoto case also. In case of combination, a mandatory notification by person or enterprises proposing to enter the combination. Here we have a threshold. There is a threshold for value, some more than 3,000 crore turnover. All these thresholds are there, but it is a mandatory notification. Now, in order to understand, we have the green channel also. The commission has, in order to have the ease of doing business, we implemented the green channel in the combination also. So the last point is for combination. The first 3 points is for the antitrust. How we receive the information, or how we take up the case, how the commission takes up the case. So enforcement function. So previously I mentioned that this section 3, 4, 5, and 6 are the 4 pillars of competition law. So these are the important enforcement function the commission is doing. So section 3 deals with the prohibition of anti-competitive agreements, and the section 4 deals with the prohibition of abuse of dominant position, and section 5 and 6 deals with the regulation of combinations. So we will deal with each and everything one by one in the next following slides. So this, in order to understand what we are going to see the next few slides, I just brought it into these slides. If you see this anti-competitive agreement here, no person shall enter into an agreement that is likely to cause appreciable adverse effect on competition. So AAEC, this is the most important thing. In order to understand the anti-competitive agreement, the authorities usually used to look into whether it causes any appreciable adverse effect on competition or not. But having said that, if you go to section 3.3, that is an horizontal agreement, and section 3.4, which is dealing with the vertical restraint or vertical agreements. Here, as far as these horizontal agreements, so we are going to deal all these things in the subsequent slides in detail. So, as far as this horizontal agreement deals with section 3.3 means a cartel. So 3.3a deals with a price, how they are determining price, the cartel, why the cartel forms, for the reason for determining price, that is the one reason. Second reason for limiting or controlling the production or supply, investment or technical development. This is the second, this is 3.3b. The limiting or controlling the production, supply, investment or technical development. Or 3.3c, sharing the market or source of production. And 3.3d, bid rigging or collusive bidding. So these are the cases. So I will explain you it based on the cases. See, there is a commission imposed some 6,000 crores penalty on tire companies, this cement companies for cartel, in the cartel allegation against them, and the matter is pending before NCLAT. Since this particular order is available in public domain in Commission's website, I am just dealing with only from the Commission's perspective, what happened in the Commission. So the cement companies, they are determining prices. They are using a platform of Cement Producers Association. They have the platform. In the platform, they are just gathering and they are deciding the prices. They are determining the prices, or they are limiting or controlling the production. Wherever some company in some state, if the prices of cement comes low due to some monsoon. Example in Kerala and Karnataka during the month of June or July, if it is an active monsoon, the need of cement will go down. the construction activities will come down due to the monsoon. So that time the need of cements may go, the prices may go down. So in order to control that, they will limit the production in that particular area. Therefore, they maintain the prices. This are one thing I have to tell you. All this discussion for academic discussion, not to be quoted for any journal or any newspaper. It is just for an academic discussion and it is within the college campus only. And apart from that, I am going to discuss only with the cases already decided by the commission, though the cases are not attained the finality, though they are pending before the appellate forum. I am just sharing some information related with the cases available, related with the details available in the public domain. Then the sharing of market or source of production. So sharing of market, so Karnataka, you can have your market. A company A says that you can have the market in Karnataka, I will not enter that particular market. Company B says that, okay, I am having market in Tamil Nadu, so you should not enter that particular market B, that Tamil Nadu market. Like this, both A and B, both companies, they are just colluding. So this is the sharing of market or source of production. And bid rigging. Bid rigging, as far as the bid rigging is concerned, so this is the most important thing. If you see, the public procurement by Indian government, it amounts to around 29% of India's GDP. The total GDP, the public procurement by the state government, central government, all the departments, PSUs, and all these companies, whatever procurement they are doing annually, if you take that and calculate, you can have that around 29% of India GDP goes around 29 to 28 to 29% of India GDP goes to the public procurement. In this public procurement, the bid rigging or collusive bidding is too much. In the railway, we are seeing so many cases, reference cases we are receiving from Indian Railway, one of the most cartelized sector, and the people are sending so many complaints to us. So the competition commission has to look into those things. So we will go into detail on all this horizontal agreement. We call it as a per se rule. So it is presumed to have an appreciable adverse effect on competition. If this kind of agreement, see, that is the difference between competition law and the contract law. So what is the most important difference here? Agreement means in contract law, you need to have two parties, you need to have a formal undertaking or formal signing, and you need to have some kind of consideration, everything. But here in competition law, the agreement, the word agreement is a nodding of head by a competitor. If they go and meet in one get together party, they are saying, sir, from next week we are planning to increase our prices. A competitor A says, the competitor company B says, okay, he just nod the head. And both are increasing the price in the next week. If these things happen, the nodding of head is enough. That itself called as an agreement in competition law. So here you no need to have formal agreement. Informal chat is enough. No need to have any signed agreement. Informal understanding is enough. So that is the difference between contract law and the competition law. So now, so here the standard is little higher. We kept our standard little higher in order to curtail this cartel behaviors, not only cartel, the anti-competitive behaviors. Now, vertical restraint that comes under 3(4). There we have all this tie-in arrangement, exclusive supply agreement, exclusive distribution. So we will deal with one by one detail. But the difference between vertical agreements and the horizontal agreement is that here we'll apply the rule of reason. The burden is on CCA to prove the appreciable adverse effect on competition. So here we will apply the rule of reason. If they have a reasonable reason that they have a justification for doing this kind of an agreement, then that particular agreement is allowed. So I'll explain that also detail in the subsequent slides. And if you see this abuse of dominant position, this is one of the most important thing, and the case of Nandini squarely falls in this abuse of dominant position. whether Nandini is dominant in Karnataka, what is the market share of Nandini in Karnataka, what is the market share of Amul in Karnataka. So if you understand that particular thing, then you can understand the competition laws, the section 4 case properly. The relevant market, first the relevant market, what is the relevant market in this case? The production of milk or milk products is the relevant market. So relevant product market, what is the relevant geographical market? Whether you are going to take the geography of Karnataka as the geography or India. If you take Karnataka, then Nandini will be dominant because that is the state product and that state PSU, and it was promoted by the state public sector undertaking. So therefore, the Nandini will be dominant if you take Karnataka as the relevant geographical market. However, if you take India as the relevant geographical market in that particular domain, then Amul will be dominant. So I am not going into the controversy. I'm just, in order to understand easily for you the competition law issues, I'm just referring with this case. I'm not going into the controversy whether it is correct or wrong. I don't know. But in order to easily understand, so I'm just explaining you. So the relevant market is more important to prove this abuse of dominant position. So before going into the looking into the competition issue, first the commission in section 4 cases, the commission usually look into the relevant market. And in the relevant market, the commission see whether he is dominant or not. Once the relevant person is not dominant, then the competition law violation we will not even see. If the person is so small, we will not look into the competition issue at all. Okay, so next I'll explain you that also in the subsequent paragraphs. So anti-competitive agreements, the cartels. So enterprises or persons agree to cooperate or limit or control price or distribution or production, sale, etc. A price agreement or limiting production, as pointed out previously. So this is the definition of cartel. And the hardcore cartels are the most serious violation of competition law, not only in India. If you take the other jurisdiction like US and UK, these hardcore cartels are considered as a criminal offense, and they can even arrest the office bearers of the companies who is indulged in the cartel. At least since India is a developing country and we are in the stage of development, so we thought that we keep it as a civil offense, though. But now the government has come out with a lot of important amendments in this latest 2023 amendments in the cartel also. So we are also coming out with some stringent penalty on the parties. The parties, the penalty is so severe. Even in India, it is severe. You can think about in the cement cartel, the commission imposed some 6,000 crore penalty. That is only 0.5% of the 10-11 cement companies. So 0.5% turnover, and the commission has the power to impose up to 10%. Then think about the commission might have imposed more than 60,000 crores penalty, but that would have had an impact on the tire industry as a whole. So commission went with only 0.5%. Now, this is one thing, and bid rigging. I told you that's bid rigging. Bidders agree to manipulate the process of bidding or reduce or eliminate competition from the bid. Bids for agreed prices or quantity in the procurement of goods and services. This is the way how the bidding happens mostly. Now the government of India also introduced the platform called GEM. So they are also promoting, and we are also having cartel tools, how to eradicate, how to find out the cartel in the bidding process. So this bid rigging is one of the major anti-competitive agreement, and the commission looks seriously on this issue of cartel and bid rigging. And bid rigging are mostly happening in the public procurement, where I said that 29% of India's GDP related to public procurement, where the bid rigging are so rampant. And the commission is also looking each and every sectors, and we are taking up cases from railway, coal, and other sectors also. We are taking up tire industry and other cement industry, and so many where we got the cases of bid rigging. Okay, now we are going to the section 3.1. Section 3.1 prevents any enterprises or association from entering into agreement which causes or likely to causes an appreciable adverse effect on competition within India. These are the most important things within India. So you can ask, OPEC is a big cartel. All these oil producing countries, they are just in the Middle East, and even Russia is not now part of that particular oil producing. They had a problem in Ukraine. And before that, even the Russia, US, and Saudi Arabia, they'll decide, the Middle East, UAE, they decide the prices of petrol. It is a big cartel, international cartel. But competition commission is not having the jurisdiction because it is within India. So we have to look into within India, but it effect is there in India. We can take up, but nobody is going to listen. That is the reason why we have not taken those cases. The Act clearly indicates that an agreement that is in contravention of Section 3.1 shall be void. Which agreements are in contravention of the Act? So any agreement which restrict the production, supply, distribution, or acquisition or control of goods or provision of service, and which create a barrier to the new entrant, or driving the existing competitors out of the market, or foreclose the competition by hindering entry into the market. These are the agreements which, so these are, we consider this kind of a conduct as an anti-competitive. The provision to the Section 3 of the Act provides that the officer shall not apply to joint ventures. Yeah, we have some relaxation. Joint ventures, if they are proving an efficiency and they entered with the aim to increase the efficiency in production, supply, distribution. So those joint ventures are excluded. So, but we need to prove it. Whenever we receive an allegation, if it is a joint venture company, they need to prove that this joint venture really increases the efficiency. The horizontal agreements are the arrangements between enterprises at the same level of production. We have already seen this. The Section 3.3 of the Act provides that such agreement includes cartels, engagement, the identical or similar trade of goods or provision of service, which directly, these are available in our sections. It is mentioned directly or indirectly determining the purchase or sell price, limits or control production or supply, shares the market or the source of production, directly or indirectly results in bid rigging or collusive bidding. This is our section. Section 3.3 deals with all these things. Under the Act, the horizontal agreements are placed in the special category subject to the adverse presumption of being competitive. This is more important. The per se rule is more important. Under Section 3.3, the Commission will look into their conduct very seriously, and it is, if the agreement is proved, then automatically the adverse presumption comes that there is an appreciable adverse effect on the competition. So we don't want to prove the AAC. This implies that there exists and presume that an agreement is anti-competitive and it is having an impact on the particular market. That is the reason why the horizontal agreements are so severe when you compare to the vertical restraint or vertical agreements. Vertical agreements are those now, not only the now vertical agreement, now in the new regime of 2023 amendments, the government of India has moved one step forward. Now, urban spoke cartel, also they brought in buyers cartel. They brought in the buyers cartel also. So they moved one step ahead. Now the Competition Act is expanded. So more cartels are included. So those things I have not covered, but definitely I have a word with your director, and in the next semester we will have one session exclusively on new amendments. What are the amendments happened and what is the impact on those amendments? So vertical agreements are those agreements which are entered between two or more enterprises operating at the different level of production. This is just like an upstream and the downstream entities, upstream market and downstream market. suppliers and dealers. And the per se rule is not applicable to vertical agreement, and the vertical agreement, hence the vertical agreement is not per se anti-competitive or not appreciable. So here they have the rule of reasons, they'll apply the rule of reasons. You need to prove the case. That is the reason so many app-based cases, they are not able to prove, we got cases against Ola and Uber. But the commission closed those matters because we saw that there is some kind of a reasonability that they are giving good choice to the consumers and also to the drivers, the online platforms at the initial stage, at least during the initial stage. Now, when after we are closing, we are receiving more complaints on those platforms, but we are looking into those issues also. So, according to the statute, it includes the tie-in arrangements. So, I told you these are the vertical agreements. So, exclusive supply distribution and tie-in arrangement, and the refuse to deal and the resale price maintenance. Tie-in arrangements. The best example for tie-in arrangement. You can now see that Amazon Prime or Reliance Jio. So this Amazon Prime, I think so many people are having Amazon Prime account. If you are having that account, they are saying that they will deliver the product within 1 day. This is an example. So you are having one streaming app account. You are getting a product in the platform also, quick delivery platform also. So this is the tying arrangement. So they are tying two different products. In order to sell the products, they are tying two different products. This is tying arrangement. The ingredients for tying arrangement, there must be two products. So the streaming in the streaming app is one product, and one delivery app is another product. Though so Amazon has tied these two products. The seller must have a sufficient market power. So in this case, Amazon is having a very good market power in at least in the delivery market, and Amazon Prime is picking up in the streaming market, and they don't have that much of market power. And the tying arrangement must affect a substantial amount of commerce. And in order to prove if there is a case, and you need to prove this particular tying arrangement is affecting the market in the downstream market or the market in the streaming player. Like if you say the Netflix is not having any other delivery app. Therefore, Netflix has to fight only in this particular market of streaming market with the Amazon. But the people, since they are getting two benefits, one is streaming app from Amazon, and another is delivery is happening within 24 hours. So people prefer more Amazon Prime rather than Netflix. So once the Netflix feels that it is affecting it, obviously they can approach the commission for this particular time arrangement. That time the commission will call the Amazon and will ask what is the reason why you are paying and how it is beneficial to the consumer and how it is not affecting the competitors. That is more important in both the products, streaming product also, in the product of this also. So this is one time arrangement. And a refuse to deal. So a dominant player, he can say that I am refusing to sell or refusing to do business with you. So that can happen. In some cases, we got cases that some of big companies, they refuse to deal with the parties. Even in one of Visco stable filed a matter, the commission dealt with this refuse to deal concept. So resale price maintenance, any agreement to sell goods on condition that the prices to be charged on the resale by the purchasers and the prices stipulated by the seller unless it is clearly stated that the prices lower than those prices may be charged. The resale price maintenance, there is a clear case against Hyundai, the car manufacturer, who has issued an email to all its dealers that they should not give less than some kind of a discount. The commission investigated that matter and the commission imposed penalty on that particular matter also. So this kind of resale price maintenance by a dominant player. And another important thing, as far as section 3(4) is concerned, the market power also, the commission used to see the market power, whereas in 3(3), no need of any market power. The particular entity, whether it is having any market power or not, that they will not look into section 3(3) cases. Whereas in section 3(4) cases, only a market leader or the entity or enterprises which is having some kind of a market power, only they can do this kind of activities. So Hyundai is the second largest car manufacturers at the time in India. So we imposed penalty on them also in the resale price maintenance. The exclusive supply agreement and exclusive distribution agreement, the agreement restricting any manner the purchaser in course of his trade from acquiring or otherwise dealing in any goods. So they have an exclusive agreement. You can even have this exclusive distribution agreement also. The perfect example for exclusive distribution agreement is that you can see only in Vivo phones, there are some models, they are available only in the online mode. Even if you go to the Vivo showroom or the Oppo showroom, it is very difficult, or that particular model is only available in online mode, not in the offline mode. So that kind of exclusive distribution agreement. So we got a case just like this on exclusive distribution agreement also against Flipkart, that they have exclusive distribution agreement with some, I think one, the 2 states, that particular book was released in the Flipkart first, and that particular book was available only in the Flipkart. And we received a complaint whether it is correct or not. But since there is a rule of reason is there in 3(4), and the parties are able to establish that it is reasonable, then we allowed that. Exclusive distribution agreement, but in most cases it is not anti-competitive. But in few cases, if the particular product, if there is no substitute for the particular product, then in those cases it is anti-competitive. So we have a leniency program. This is most important. How to detect the cartel and bid rigging? It is very difficult because, as you said, most of the people, those who are indulging in cartel, they will not enter into any formal agreement or formal signature. There is no formal things. So here everything is informal, and they have all this information hide. And it is very difficult to detect the cartel. So the commission is having a program, a leniency program here, in order to detect the cartel. Since the cartels are difficult to detect, enforcers should be helped in their ability to detect by various means and instrument. And the most effective being the leniency program. And the second most important thing is dawn rates. The commission has done, the DGM of the commission. They have done the dawn raids in all over India, mostly in the cartel matters. In few cases, in the abuse of dominance also they have done. But mostly in cartel matters, the dawn raids are most effective to. So they are the most effective to detect the cartel. And the Competition Act empowers the Commission to grant leniency by levy a lesser penalty. So the leniency program is that a member of a cartel who comes forward and provides a true, full, vital information regarding the particular cartel. If he comes forward and provides all the details to the commission, the first comer will get 100% lenient on the penalty. So this is that. The CCI notified that lesser penalty regulations in 2009. The first applicant can be granted a reduction in penalty up to 100%. And the disclosure enables the commission to form whatever disclosure that particular person. So this helps most of the multinational companies when they started acquiring the Indian companies. And once you start doing the research, or once you start doing the exercise of looking into the balance sheet of that particular company, and they found that these companies are in frequent negotiations or frequent communications with the competitors, then these companies, they will come forward voluntarily. They will come forward and they will file a leniency petition before the commission, and they got the 100% waiver on penalty. The instance, there are 3 or 4 instances like this. A foreign multinational company trying to acquire an Indian firm. And once the Indian firm got acquired, and if you start looking into the balance sheet and other things, there are a lot of communication happened between the competitors. Then they voluntarily file the leniency petition before the commission and they take the 100% waiver also. These things happen. This disclosure enables the commission to form a prima facie opinion, existence of a cartel. In matter under investigation provides us evidences which establish the controversy. There are two scenarios. One scenario, already existing information, already existing investigation also. The investigation is pending before the DG. Therefore, the DG at the time of before DG submitting a DG report to the commission, if they are filing the LP and in the matter they are providing a vital information and they are disclosing full, true and true disclosure happens, then obviously commission will give 100% waiver. And the second applicant, in this case, there is a queue. It is always a queue. The second applicant also in the same matter, he can get the reduction up to 50%. The third applicant can get up to 30%. But the third applicant, and after the third, now the commission has extended this. There is no limit to that. Previously, it was only up to 3. Now it was extended. Now the commission can apply its mind and give the reductions. The priority status of the applicants will be marked. Yeah, once we receive that application, the commission, the priority status will be marked, but that priority status we usually won't communicate to the parties. At the stage of final order, that was communicated to the parties. So now we are coming to the dominant position. The dominant position, so that is the example of Amul. Whether Amul is dominant in India in the production of milk or milk products, the production and sale of milk and milk product, whether Amul is dominant, or we can say whether Google is dominant in the search engine market in India. So a dominant position means a position of strength enjoyed by an undertaking in the relevant market, which enables it to operate independently of any competitive forces prevailing in the relevant market. I told you, relevant market is very important for the this section 4 cases. Relevant market is very important, and whether it affects its competitors or consumers or the relevant market in favor. So this is how the dominant position works. In the dominant accounts for a significant share of a given market. Amul is, I think Amul is having some 30 to 40% market share in North India. In Karnataka, if you take the relevant geographical market as Karnataka, Nandini is the dominant player. So the if you whether any competition violation happened in that issue, if you look into that, no, I think not. Nandini is a dominant player in Karnataka, whereas Amul is the dominant player in India, if you take India as the market. And has a significant large market share than its next largest rival. That is most important. And the many legislations do not provide for any arithmetic figure to the identify the market share, but some consider a market share of 40% or more for the dominance. So what is this? Why the competition are so significant now? Just have an example. You know, previously some 10 years back or 10 or 15 years back, we have STD booth in every nook and corner of streets. What happened to that STD booth? Now you are not even able to see the STD booth. And I think you remember there is one application, one social networking site called Orkut. What happened to that Orkut? This and there is a communication system called pager. So what happened to the pager? During my college days, the pager was so popular, and then the Orkut was so popular. People used to communicate in the social. At that time, Facebook was just in the budding stage, and Orkut was everywhere. And the STD booth was everywhere. We don't have Android phones and the Apple phones that time. So what happened to all these things? See, innovation happens in the market, and the changes, they are totally wiped out. the market is correcting itself, or a new system, a destructive technology enters the market, and it is totally changing the total ecosystem of the market is changed. Now you cannot see the STD booth because everyone is having their own cell phones. So what is the point of having the STD booth and pager for communication? So these kind of things, this kind of innovations only happens when there is a level playing field for the competition. Competition is very important for the innovation. If you allow a dominant player to survive in the market, what happened in the case of Air India? The government sold the Air India. Now, if you have got the chances of traveling in Air India, they started giving good foods first. Then Vistara came, they started giving a nice food. Then after that, the market leader is Indigo. Indigo is the market leader who is having around some 40% market share in the domestic in airlines market. But they don't have any incentive to give food. But what happened once the Vistara and Air India started giving food, the crowd started moving from Indigo. It forced the competitor Indigo to provide their food. First, they introduced the food in the corporate clients. They started giving the food. This is how the competition plays a role. If the market is so competitive, then the players in the market, they will innovate, they will reduce the resources, and they will innovate and give a better service to the customers. If Air India is kept by the government of India and BSNL, there is only BSNL and Air India in India, means that's all. BSNL will not provide you any prompt service, or Air India, no one will care. If you ask for water, no one will come back and give you water. This is the condition. But once the competition started, what happened? Obviously, it forces the dominant player because Indigo don't want to lose the share. The Indigo don't want to lose the consumers or customers to the domestic player. So they started introducing food for the corporate clients because corporate client is more important for them. So they started introducing food for them. So this is how the market works. This is how the competition works. Competition is so important. Now I am coming to the next side of the competition. See, the Air India was brought by Tata. So I went from Chennai to Delhi for attending some official meeting. So I asked for water. They delivered the water. The water is from Bisleri or it's like Himalaya, some Tata brand. Then they served food from Taj, that is also Tata brand. In the food, they had tea, coffee, that is Starbucks, that is Tata brand. Then they gave some, what can in few more items also I checked. Everything is Tata brand. So now, see, the consolidation started happening. This can only the dominant player can do like this. So who is having a market power and who is having a more money power and who is having a big packet. So only they can do it. So they are just consolidating, and in the back channel from the upstream market to the downstream market, they started consolidating. Air Asia merged with Vistara, then Vistara merged with Air India. Once the Air India becomes big, now they are planning, they are having code share agreement with Singapore Airlines and so many other airlines. Apart from that particular thing, even the products used in each and everything. Taj is giving food, and the people, those who are traveling in the flights, pilots, they can stay in the different parts of Taj hotels, and they are giving. So this kind of, see, why I'm talking all these things. The competition law is very important for a market economy. Even at each and every stage, competition law plays a vital role, whether it's in your telecommunication, whether in your Google, whatever Google you are using, Gmail or Gtalk, any Google, or big data, the information is collected using the Meta or the apps you are using like Uber, Ola. So all these places, the competition is very important. If there is no competition, a dominant player will not innovate and the dominant player will not give good service to the consumers. In order to that we have, I pointed out that objectives of Competition Act, the consumer welfare is important. So a dominant player has to give, not only a dominant player, a enterprise has to give a good service to its consumer. How to achieve that good service? So that is the most important thing. So let's see the other points. The factors to determine the dominance. These are the factors: the market share, size and the resource of the enterprises, and the size and the importance of the competitors, and economic power of the enterprise, commercial advantage. You can see, you can correlate this with the Tatas. What is the market share of Tatas, and how the size and the resource of enterprises plays a vital role. Vertical integration of the enterprises. This is more important. The people are now vertically building. You can see the Reliance is having Reliance Retail, and from the Reliance Retail they enter into Cola and all the products. And you won't believe that the products competitor like Procter and Gamble, and they started reducing this Tide, Surf Excel prices got reduced into 40-50 rupees this month. You go and check, because the Reliance is entering in all this market segment. So once the Reliance wants to enter with their disruptive price that they are charging 40-50 rupees less, now the competitors started reducing the price. This is the real competition. So, and then we look into the other factors. So the monopoly or dominant position, whether acquired as a result of any statute or by virtue of being a government company or public sector undertaking or otherwise, a perfect example for BSNL and Air India. Before Air India was given to Tata, this is the position. So they are acquiring that position and they will not even do any work. They will not do any innovation. This kind of dominance is there. Coal India Limited. See, I am not quoting anything, don't quote anywhere. This is just an observation, that's all. The entry barriers, including a regulatory barrier. There are regulatory barriers, like big sand mineral, there is a regulatory barrier. The people cannot start their own big sand mineral company because there is a regulation is there. You need to get an approach, so many authorities to get an approval. The financial risk, high capital cost of entry. Telecom companies, you cannot now start a telecom company by investing 1 lakh crore or 2 lakh crore. So that is a high cost, high capital cost company. So marketing entry barriers and technical entry barriers, all these barriers, these are the factors to determine the dominance. How will we determine the dominance of an enterprise? High cost of substitutable goods or services for consumer, and we have a countervailing buying power, market structure. These are some of the factors to determine the dominance. So dominance per se is not bad in the competition and antitrust. Yeah, this is very, very important. Indigo is having 40% market share, I told you, in the domestic industry. But the dominance per se is not bad. Yeah, it is not bad, but it abuses is bad. Once the Indigo uses its dominance to abuse its market power, then it is bad. Abuses is bad. The abuse of dominance might be felt in an relevant market. For example, I'm just telling you an example. There is Chennai to Coimbatore air route, and Indigo is having 5 flights per day. But whereas Air India and other competitors, they are having only 1 flight. And if Indigo reduces the price to the predatory pricing, we call the once the predatory price comes, I will explain that also. That holding such market power that would have the ability to set prices above the competitive level. The best example is this NSE case, National Stock Exchange versus there is one previous stock exchange, MCX and National Stock Exchange. What happened is MCX trying to introduce a new derivative. They are trying to introduce a new derivative in the market. But NSE is an established player. That is the largest share market in India. Previously also, and when we dealt with the matter also, that time also. MCX is trying to enter the particular market by introducing only one derivatives. There are 4-5 derivatives in the segment. So they are introducing one particular segment where NSE was not there. Once a player MCX has introduced, they have the cost for that because they want to establish a office, they need to recruit an employee. Then they started pricing for that in order to create an infrastructure. Whereas for MCX, the cost is zero because they have already having their own infrastructure, own manpower, everything. So what happened? NSE started charging in that derivative zero. Whereas this fellow cannot give that particular price because he is having a cost. So he filed a complaint to the Competition Commission saying that there is this abuse of dominance by NSE and they are doing predatory pricing. The commission dealt the matter and imposed 54 crores penalty on the parties, 54 crores on the NSE. And the matter was challenged. It was upheld by the erstwhile compact also. Our previous appellant body, they just upheld this particular order. Now what happened? What is the significance of this? Only a dominant player can do like that. The predatory pricing, only the dominant player can do. And the dominant player can sell products or provide services at inferior quality. BSNL, if there is only one company which is there in the market, that is if it is Air India. So this is a perfect example is Air India. Inferior quality means Air India. They never bother about the customer satisfaction before selling. I'm talking about not now. Can also reduce the rate of innovation that would otherwise exist in the competitive market, rate of innovation. So this is the most important thing. Why you should not allow a dominant entity to survey in the market. A dominant entity, if it is abusing its market power, then it needs to be curtailed that particular thing by the commission. When a dominant undertaking directly or indirectly imposes unfair condition in the purchase or sale of goods or services, or price in purchase or sale, including predatory pricing, the NSE case, I told you, this is the case of goods or service. Limits or restrict the production of goods or provision of services or market, technical or scientific development relating to goods or services to prejudice of consumers. When the technical and scientific development happens, I told you one thing, this particular era of STD booths got totally vanished. What happened to that? A new development came, new scientific technical development came, that is cell phone. It destroyed the market for STD and ISD booth. So totally that particular market was vanished. So this is the competitive market. So next, after this cell phone, what we are going to have? Whether this Alexa of Amazon or something like that, you can have it in your watch. We don't know. But if the market has to be more competitive, there needs to be an innovation, there needs to be a scientific development. And in order to have this scientific development and innovation, the dominant player who is sleeping or who is so lethargic will not do that. That is the issue in this abuse part. The dominant undertaking indulges in practices and practices resulting in denial of market access. It makes the conclusion of contract subject to acceptance by other parties of supplementary obligation, which by their nature or according to commercial usage have no connection with the subject of such contract. In one relevant market to enter another relevant market. So I told you that Amazon Prime is having in the streaming service, they are also there, and in the delivery service. So this is not an abuse, I'm saying. See, like Air India, they are using their own brand, Taj brand, to provide food, and they are using their own Starbucks to give coffee, and they are using their own brand, Bisleri or Himalaya, to give water to the Air India customer. So that is not wrong, unless if a uses his dominant position in this particular market, in the Air India market or domestic market, and enter into another market or protect the another market. So that abuse is wrong. Okay, so we have to prove that beyond reasonable doubt, we have to prove that they are abusing using this dominance, but they are not dominant. See, Air India is not dominant in the domestic market at all, first of all. So that is because Indigo is dominant, they are having 40% market share. So this predatory pricing is that NSE case. The sale of goods or provision of service at a price that is below the cost of production. See, for NSE, it is already into 3 derivatives and it is an established player in the market. It is having every setup. It is having all the infrastructure, manpower, everything is there. So for them, entering into a 4th derivative it is not going to have any major cost for them. But for a new player to enter into that market and establishing the infrastructure for the 4th derivative is very difficult because he is not present in the first 3 derivatives. Therefore, if MCX is giving the 4th derivative product at 0 cost, and the person who is competing in the 4th derivative is not able to withstand with that cost, then he will lose the market. Like I'm giving you another example. If Netflix is only in the streaming market and they are charging 1,000 rupees per, but since Amazon Prime is in both streaming market and also in the delivery market, in the delivery market, they are giving you a service of 24 hours delivery, within 24 hours delivery. In the streaming market, they are charging you only 500 rupees means people will prefer Amazon Prime only, more Amazon Prime, not Netflix. So this is the deliberate strategy usually adopted by the dominant firms. And what happened until the Netflix can survive? At one point of time, Netflix will lose all its customers and it was eliminated from the market. Then the Amazon Prime will increase its customer charge from 100 rupees to 1,000 rupees. So just for an example, I am giving all these names. So don't take the name as per se. Please leave the name. It is just an example. You can keep it as an example. Generally continues till the competitors are eliminated. That is more important. Until they will keep the price 0. NSE will keep the price 0 until MCX will move out of the market. Once the MCX will go out, then the NSE will increase the price to 100. I am assuming some price they will keep. They will charge some price from the consumers. Once the competitors have been driven out of the predator can raise the prices and earn higher profit. If the dominant entity continues with a lesser price for a longer period of time, it will benefit consumers also. But the problem Reliance Jio when Reliance Jio introduced in the market, it entered the market with a very less price. So everyone, all the competitors like Airtel and everyone alerts that the Reliance Jio is predatory. They are doing a predatory in that particular market. But that is not the case. After 2 years, the Reliance has increased its cost also. Now they are changing all this cost. So it is not like filters before adjudication. How we in the abuse of dominance cases, we usually used to determine the dominant, then determine the relevant market, then the determination of relevant and geographical market, then prima facie we will see whether there is any abuse in the market. So relevant market means, as previously pointed out, like in this Nandini or this, what is that, Amul case, the relevant market means a market which may be determined by the competition authorities with reference to the relevant product or the relevant geographical market or both. Therefore, the product and geographical area are the two main ingredients for determining the relevant market in competition analysis. A market comprising all those products or services which are regarded as interchangeable or substitutable by the consumers. A reason for characteristic C, Airtel may be substitute for Jio because they are providing same service or similar service. But WhatsApp may not be, though it provides a communication service. WhatsApp you can message and you can call. But WhatsApp is a platform. It's an online platform, online communication platform. Whereas Airtel and Jio, they are service provider, telecom service provider. But all the three are providing similar same services. but you cannot say that they are substitutable. So in order to understand the market, this is one of the example. The geographical market, as said, whether Karnataka is the relevant geographical market or India is the relevant geographical market. Means a market comprising the area in which the condition of competition for the supply of goods or the provision of services or the demand of goods or services are distinctly homogeneous and can be distinguished from the conditions prevailing in the neighboring areas. So distinctly homogeneous. For this, I have to give an example. In one of the case in US, there is a case against a supermarket firm. There is a national highway. It is like an expressway. Closed expressway is running in the middle of the town. There is one supermarket is existing in the left side and one supermarket existing in the right side. The villagers, in order to come to the right side supermarket, they have to take some half an hour travel, and they have to cut a U-turn, and then they have to come back to the reach the right side supermarket. So this is the case in US, where the US authorities, they have decided that since they have the people who is living in the left side, they have to take some half an hour drive and take a U-turn and to reach this particular other side of the supermarket. The supermarket existing in the right side and left side are homogeneous and distinctly different. And this is a separate market, relevant geographical market. They have defined and the case went. So this is how they will define the case. They will narrow down the geographical market, or they may expand the scope of the geographical market like India. In most of the cases, if you see, if you look into the commission's order, in most of the cases, we have taken India as a geographical market. In some cases, we have taken the state. In some cases, we have taken a district. And in some cases, we have taken a city. Like in DLF cases, we have taken only Gurgaon, not even NCR. NCR means National Capital Region. It includes Noida, Greater Noida, Delhi, some other parts of Haryana and Gurgaon. But we never took NCR as the part of geographical market. We took only Gurgaon. In Jayaprakash Associate case, where the commission imposed 18 crore penalty in the real estate matter on JP Infratech Limited, in that matter also the commission took the Greater Noida as the market. Not even Noida, Greater Noida as the market. And this is one thing about the relevant geographical market. And we have a remedies, section 27, behavioral remedies. Cease and desist orders. The commission passes cease and desist orders. If you want to see the most important cease and desist order we have passed in this Google matter, which was upheld recently by our appellant body NCLAT. So that order is very important, and you can have a look into that order also. And there is one Grazim order, 62 of 2016. It is pending before NCLAT. Where we have mentioned this affirmative actions require violator to change certain practices, where we have directed the Grazim to disclose the viscose staple fiber prices in its website. Though they have got the state for that, this kind of behavioral remedies also the commission can do in section 27. And penalties, fine up to 10% of turnover. In cases of cartel, 3 times of profit. A fine based on various mitigating and aggravating factor. Before imposing penalty, the commission used to look into these mitigating and aggravating factors, various factors. And apart from this, we have a power, and we have not used this power until now. The commission has reluctant to use, because this is a very important power. Section 28 of the Act, which gives the commission to the division of an enterprises enjoying a dominant position. Such enterprises does not abuse the dominance. So there is a talk that the commission has to use this power for some big tech data companies. We don't know how it is going to have. So individual liabilities, this is also very important. Individual liabilities, the person who is manning the company, they are responsible for the conduct of the company. So under section 48.1 and 48.2, they will be penalized. 48.1 and 48.2, see, you can see 48.1, 48.2, the individual liability comes. And now we can see the hierarchy. What are the hierarchies? I think the time is already 12:10. So I'll just go a little fast. So the hierarchy of appellate process. So previously we have erstwhile compact competition appellate tribunal. Now we have the national company law appellate tribunal. That is our NCLAT, is our appealable body. And from NCLAT, the orders goes to Supreme Court. So we do. And basically, but under writ jurisdiction, the parties challenge the orders of CCI in high courts also. This is our appellate process. And what now I am just coming to the latest developments in Competition Act. The competition amendment has come in 2023. What is the need for this amendment? The global changes in market dynamics led to the new age economics happened. The digital market, emergence of digital market, the emergence of e-commerce, emergence of new market models such as aggregators, market models. So all these things happen in not only in India, the world, which necessitated the amendments to the Competition Act 2002. So they brought these amendments. So important amendments are, now I previously told, in the cartels, they brought the buyer's cartel. In the hub and spoke cartel also included now. Now, apart from leniency provisions, we have leniency plus. If the cartel participant gives more information about any other cartel, existing cartel, then it is considered as a leniency plus, and he will get more benefit because of that disclosure. And the settlement, this is most important thing. Until now, we don't have any provisions of settlement. So we are introducing, using these amendments, that they have introduced the settlement also and the commitment also. The competition violators, they can give the commitments before the commission, and this will have an impact on the penalties. And another important thing happened in this amendment is the global turnover. So they have placed it in for the definition of turnover, they have not mentioned it. However, it is mentioned in the explanation. So I think they are planning to use this issue of global turnover whenever the particular merging party, when they have no asset in India or something like that, or when the particular big companies, they are not having any turnover or in India. Yeah, so it is related with that. And now, as far as the combination is concerned, the time limit has reduced from 210 days to 150 days. There is the cartel has been excluded from the settlement arrangement. Is only for the settlement is only for abuse of dominance and this vertical restraint matters, not in the cartel matters. And the compensation also, I think they have introduced the provisions for compensation. And this amendment has brought the green channel as one of the provision, and this green channel approval is trust-based approach, where the parties will disclose that this is that there is no impact on competition, and they will disclose this. So the commission will allow the green channel approval, and already this green channel approval is present in the commission, but now we are giving them a clear legal provisions. And there is this de minimis exemption for combination below a certain threshold. That is also they are introducing. This is for, because what happened in the Facebook, when the Facebook purchased this WhatsApp, that particular company, they have not even filed the merger application here in India, saying that though in India they have the more consumers, but they said that we don't have an asset in India, we don't have an income in India, therefore we are not filing. So in order to avoid those things, then the commission thought, and then this amendment is going to cover those. Value of transaction is another criteria they are notifying. And now the power of DG, appointment of DG by the commission in consultation with central government, that is also they are bringing in. And the existing provision of NCLAT are proposed to be replaced. The power of contempt procedure they are introducing for the NCLAT. And what are the challenges moving forward? What are the challenges to the commission as an enforcer, as a competition enforcer and competition authorities? We are facing a problem in the market, because the digitalization is creating new areas. It is bringing new market dynamics. That it is creating two-side market, three-side market, multi-side market. So many issues are arising, which never ever previously, if you say 20 years back, when the Competition Act was enacted, that time when the parliamentarians never felt this kind of things will happen. Now, so many things have happened. Multi-site market, this markets are growing so effectively. So this kind of digitalization is changing the market characteristics that affect the likelihood of pollution. So artificial intelligence or machine management, artificial intelligence or polluting. So this kind of, and the direction and magnitude of the effect is still not clear. No one, even the developed jurisprudence like US and European Union, even they are very difficult to understand where this magnitude is going to take forward. And if you see, the pricing algorithm is a software program for determining the price of the product or service. And the sectorial inquiry in the e-commerce by European Commission revealed that about the response track online prices of competitors. So everything is now online, and the pricing algorithms are fixing the prices, and the use of the pricing algorithm has increased because of big data and computing power. So all these are the new challenges which the competition enforcers are facing, not only in India, all over the world. And we are using the platforms like OECD and other international competition network platforms to discuss how the other authorities are dealing with this problem, how they are managing this problem, because the artificial intelligence, if you see the prices of from Chennai to Delhi, if you see the prices of air ticket, all the prices are similar, 5,000 rupees. Now it is fixed by that artificial intelligence. So whether you are going to say that the artificial intelligence are colluding on behalf of the man or the person who is behind that, so it is very difficult whether we are going to arrest the artificial intelligence or we are going to penalize them. We don't know what. So apart from this, in order to have this, apart from the latest amendments, there are also a parallel discussion going on to introduce a digital competition law. So digital competition law, they are planning to bring it, and they have set up a committee. The government has already in the process of initiating the committees in the discussion, which would introduce the rules which tech companies, platforms function in India. So these are the future things we are planning to do. And this is my lecture on Competition Act. So any questions? Anyone having any questions, you can ask, please go ahead. So not only questions, if you are having any interest on practicing in competition law, anything related with how to do the internship with CCI, any query regarding that also, I am ready to answer. We'll have an interaction for some minutes related with internship. So if anyone is doing interest on internship, you can contact your director or your professor, and if they have a word with me, definitely we will arrange an internship. And as I pointed out in previously, we are planning to introduce internship programs in our regional offices also now. So you can do, but I always advise you, you have your internship in Delhi. If you are having a resource, please go to Delhi, because you will be attached with the different divisions in 2 or 3 days, with economic division, legal division, combination, and antitrust division, so that you can understand how the competition commission is working, what is the significance of competition law, etc. But regional offices, we don't have that much of infrastructure, but at least we have a senior officers posted here. Definitely, we will also help you to understand the competition law, but you will get more exposure if you are posted in Delhi. Those who are not having the resources, you can join in regional offices also. Okay, so somebody in the chat has posted something. Sir, what is your view on Manipal Hospital buying hospitals like Columbia Asia and in many hospitals. Don't you think that is an anti-competitive in nature? Yeah, but the issue is that very good question. At least somebody has posted a relevant question. Even I saw that Manipal hospital is building, but even then, the hospital infrastructure of Manipal is not number one. Apollo is the number one. Apollo is having more market share than Manipal. If you go and look into that, how you are going to look that particular hospital? Because the problem is that here the relevant geographical market is more important. If you take Bangalore as the market, then Manipal is a dominant player. But if you take India as the market, then Apollo is the big player. So that is the more important. If you are in Bangalore, the number of bed occupants, or the number of beds you are taking that as a yardstick, then obviously Manipal is having more hospital beds in Bangalore. But we don't know how they see. As I pointed out previously, dominance is per se not wrong, but abusing the dominance, how Manipal is abusing its dominance. If you are having anything on that, definitely we will look into that. But if a player who is merging, who is again and again merging, but if Manipal is the only player in the Bangalore market and it started taking all the private hospitals in the Bangalore, then the commission can look. But see, Manipal is not only player in Bangalore. You have the government hospitals, you have the government institutions. There are so many government hospitals, big hospitals in Bangalore. So they are substitutable to the Manipal. Therefore, Manipal is not dominant even in Bangalore. If you take the market, if you narrow down the market to the level, private hospitals in Bangalore, the provision of services of private hospitals in Bangalore, then only the Manipal will come. Even in that private hospitals, then you will have more number of other hospitals who is providing the same similar services. So, per se, it is not wrong, but yeah, there is some issue is there, because once you become huge dominant, then authorities will definitely look into that. Before allowing the merger, they need to take approval from the combination of the CCI, and the CCI might have looked into that before. Yeah. Any other queries? Thank you, sir, for your practical example to the concept. I have one question. In Bangalore, Kapagowda International Airport have made an agreement with government that there should not be airport in surrounding of 150 kilometers. Does this agreement restrict other state in building the airport? Hosur airport establishment is blocked by. Very good question. Even I had a discussion with my friend in Hosur. And they have an issue on this. See, the problem with this is that the same thing in Delhi, they have the Delhi GMR airport. When the government of India entered into an agreement with the GMR for building the Delhi airport, they said that next 20 years you should not establish any international airport in nearby area, at least 50 kilometers or 100 kilometers. This is a normal agreement, because a private player, one who is investing crores of rupees in that particular airport, he need to recoup his investment. So that you have to give him a space, time to grow. Otherwise, how GMR will invest that 10,000 crores in that Delhi airport? So here, in the case of Kapagowda, the private player, one who developed this airport, it is a greenfield airport. It is from the scratch they developed this Kapagowda airport. Therefore, the government of India has entered into an agreement with them that they will not develop any airport within the vicinity of this airport within 150 kilometers. I think it is not 150 kilometers, around 100 kilometers, because Hosur is near to Bangalore. Therefore, it is coming out. So it is not per se, it is not violative, because they have to develop that particular area. But however, now what happened in Delhi airport? Once this airport has reached his potential, Delhi airport has reached its potential, and there is no more space for the growth, then the Greater Noida, they established another airport. Once this Kapagowda airport has attained his passenger limit, then obviously the government can relax the rule. But before doing that, government has to allow that private player. Otherwise, the private, see here, the government is not investor. The private parties, they are bringing the money and they are investing in the airport infrastructure projects. Therefore, this is not anti-competitive. Very good question. Even I had a discussion with one of my friend in Ozu. They contacted us from the association. They said how they can do like this. They asked me, but this is not a competition issue. It is a business prudence decision on based on the business. They are doing this. Okay, it's not a competition issue. Any other questions? If any more questions, we can have it or we can complete. And I have to thank this many students to listening me. Whether I bored you or not, I don't know. I thought I have to give a live example. That is the reason why it took a lot of time. So next time we will have interaction. We will organize some event with your college. I will have a discussion with your director. We'll have more events. And I'm expecting some students to do the internship from your college. We are expecting 1 or 2 students. And you keep in touch with me. Definitely, I will arrange the internship programs. Whoever is willing, and definitely we will arrange for them. Okay. Thank you very much. Yeah. Thank you. And
Thank you, sir, for the enlightening session and for the wonderfully engaging replies. We have now come to the end of the session. I now request Professor Chanjana, Faculty, CMI University, School of Legal Studies, to deliver the vote of thanks.
A good day to one and all of you. Indeed, it's a privilege to give the vote of thanks today, particularly to our special guest, Shri K.P. Anand, the Joint Director for Law, the Competition Commission of India. Sir, we are actually thankful to you for having given a general overview on the laws regarding competition law. It was just not a general overview. Every section of the statute was analyzed and spoken with practical examples. So I don't think any other teacher would take this pain to give a complete overview of the whole statute as such. Thank you so much, sir. In this busy schedule of yours, you found time to be part of this lecture series. I also take this opportunity to thank the management of the university for having given this opportunity to get in tie-up with the Competition Commission and to conduct such lecture series. I'm sure that the students are going to benefit a lot out of this, and we hope and we expect them to be part of this. Yes, sir.
yeah, ma'am. Before pointing out, we can take one photo. You can ask all your students to take switch on the video cameras
Yes,
at least, so that we can take one photo for Twitter, ma'am. Twitter and our social media handle.
Yeah, sure, sir. So once again, thank you, each and every one of you, for being part of this lecture series, and thank you, sir, once again.
Thank you all.
Thank you, ma'am. Thank you, everyone. Have a great day ahead.